Hello and welcome to the Minimum Competence episode for Tuesday, July 9th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover a federal judge's resignation over an inappropriate relationship with a clerk, the FTC's report on pharmacy benefit managers inflating drug costs, Trump's unlikely conviction reversal, and my column on taxing cows. Let's remember, a lie can travel halfway around the world while the truth is putting on its shoes, and read today's legal news. On this day in legal history, July 9th, 1778, 8 American states, New Hampshire, Massachusetts Bay, Rhode Island, Connecticut, New York, Pennsylvania, Virginia, and South Carolina, ratified the Articles of Confederation, marking a significant milestone in the establishment of the United States' first constitution. The Articles of Confederation served as the foundational legal framework for the fledgling nation during the Revolutionary War. This initial ratification by 8 states paved the way for the Articles to take full effect once Maryland, the last holdout, signed on March 1st of 1781. The Articles of Confederation aimed to unify the 13 original states under a national government with limited powers, primarily to manage war efforts, conduct foreign diplomacy, and handle territorial disputes. However, the Articles granted most powers to the individual states, reflecting the colonists' fear of a strong central authority reminiscent of British rule. Despite its significance, the Articles of Confederation had several weaknesses, such as the lack of a strong central government, no executive branch, and the inability to levy taxes or regulate commerce effectively. These limitations eventually led to the drafting of the current U.S. Constitution in 1787, which created a more robust federal structure and addressed the shortcomings of the Articles. The ratification of the Articles of Confederation on July 9th of 1778 remains a critical event in American legal history, symbolizing the early efforts to create a unified nation and laying the groundwork for the Constitution that governs the United States to this day. Federal Judge Joshua Kindred, who recently resigned, engaged in an inappropriate relationship with a former law clerk and misled an investigating judicial panel about it, according to a Ninth Circuit Judicial Council report. Kindred, a Trump appointee, was found to have harassed clerks and created a hostile work environment. The council's report describes his behavior as abusive, pervasive, and unprofessional, noting that his interactions with clerks were inappropriate and oppressive. Kindred submitted his resignation without explanation on July 5th. The Judicial Council of the Ninth Circuit publicly reprimanded him and urged his resignation. The council also referred the matter to the Judicial Conference of the United States for potential impeachment. The report highlighted an, quote, unusually close relationship between Kindred and a former clerk involving inappropriate contact for over 278 pages of personal text messages. Kindred's actions included discussing vulgar topics in the workplace and belittling clerks who raised concerns. The council expressed doubts about his ability to conduct himself appropriately in the future. Kindred initially denied the allegations, but later admitted to crossing professional boundaries, attributing his behavior to personal turmoil, including a divorce. The investigation also found he was drinking excessively, sometimes in his chambers. This case comes amid broader scrutiny of judicial misconduct, particularly concerning judges' treatments of clerks. The judiciary has implemented new measures, such as the Office of Judicial Integrity, to address these issues. Jamie Santos, an advocate for judicial reforms, speaking to Bloomberg Law, emphasized the importance of transparency and accountability in such cases to encourage clerks to report misconduct. Jeremy Fogel, a retired federal judge, also noted the thoroughness and unanimity of the council's order against Kindred, highlighting the serious concern over his lack of honesty during the investigation. The Federal Trade Commission, or FTC, released a report highlighting the concentration and vertical integration among the top pharmacy benefit managers, or PBMs, are driving up drug costs and financially straining independent pharmacies. The report stems from a study launched in June of 2022 investigating the practices of the 6 largest PBMs. FTC Chair Lena Khan emphasized that these PBMs, which manage 94% of prescription drug claims, significantly influence drug access and pricing. The report noted that the top 3 PBMs, CVS Caremark, Cigna's Express Scripts, and United Health Group's Optum Rx, control nearly 80% of the market. Their integration with health insurers and pharmacies allows them to exercise considerable power over drug prices and availability. The FTC found that pharmacies affiliated with these PBMs received reimbursement rates for certain cancer drugs that were 20 to 40 times higher than the national average drug acquisition cost, leading to an additional $1.6 billion in revenue over 3 years. These high reimbursement rates contribute to increased out-of-pocket costs for patients, including those on Medicare Part D. The FTC also pointed out that PBMs may engage in anti-competitive practices by negotiating rebates with drug manufacturers to exclude cheaper competitor drugs from their formularies. The FTC's study faced challenges due to some companies' failure to provide required data and documents. The agency is prepared to take legal action against non-compliant companies. Despite the findings, PBMs argue that they help reduce prescription drug costs and blame high manufacturer list prices and patents for the rising costs. The FTC voted 4-1 to issue the interim report, with one Republican commissioner opposing it. The Pharmaceutical Care Management Association, the leading PBM trade group, remains confident that the FTC's examination will ultimately show that PBMs reduce drug costs for patients and employers. Legal experts believe Donald Trump faces slim chances of overturning his conviction on charges related to hush money paid to a porn star, despite a recent U.S. Supreme Court ruling that broadly recognizes presidential immunity from prosecution. Trump's lawyers have argued for setting aside the May 30th guilty verdict, citing the Supreme Court's decision that former presidents cannot be criminally prosecuted for official acts under their, quote, core constitutional powers. However, experts point out that much of Trump's conduct in question occurred before his presidency and involved personal matters, not official acts. Cheryl Bader, a law professor at Fordham University, speaking to Reuters, noted that falsifying business records to pay off a porn star does not fall within presidential duties. Trump was convicted of 34 counts of falsifying business records to conceal reimbursement to his former lawyer, Michael Cohen, for paying $130,000 to Stormy Daniels before the 2016 election. Trump has denied the encounter and claims the case is politically motivated. Prosecutors argue that payment was part of a scheme to influence the election by avoiding a scandal. Trump's legal team contends that evidence related to his presidency, such as social media posts and an ethics form, should not be considered official acts. Legal experts like Stephen Cohen from New York Law School, speaking for Reuters again, believe these activities are unofficial and unlikely to lead to a reversal. While Trump's lawyers declined to comment, a spokesperson for the Manhattan District Attorney's Office did not respond. There are precedents for overturning convictions following new Supreme Court decisions, but Cardozo Law School professor Gary Galperin notes that even if some evidence could not have been presented, the judge may still uphold the conviction if it did not deprive Trump of a fair trial, known as a harmless error. Trump's defense is expected to fully present their arguments in a court filing by Wednesday, with prosecutors responding by July 24th. Judge Juan Merchan will decide by September 6th, and if the conviction stands, Trump will be sentenced on September 18th. And finally, my column this week on taxing cows. Taxing carbon emissions from livestock in the U.S. could significantly reduce greenhouse gas emissions, as cattle contribute 10% of the nation's agricultural emissions. Implementing a livestock tax would not only promote sustainable agricultural practices, but also generate revenue for reforestation and responsible land use. This measure could provide a more comprehensive approach to addressing greenhouse gases compared to the gradual phase-out required for the fossil fuel industry. Currently, the U.S. government spends about $30 billion annually on agricultural subsidies, a practice that effectively supports both carbonization and decarbonization of the economy. Agriculture's contribution to greenhouse gases, especially from methane emitted by cattle, is substantial yet often overlooked. Methane has a higher global warming potential than carbon dioxide, accounting for around 30% of the observed global temperature rise since the 18th century. Denmark's successful implementation of a livestock carbon tax demonstrates the feasibility of such policies. Starting in 2030, Denmark will tax livestock emissions, with rates increasing until 2035. This policy includes subsidies for carbon capture and reforestation, balancing environmental goals with farming realities. However, Denmark's policy focuses mainly on carbon dioxide, missing the full impact of methane emissions. The U.S. could enhance this model by including both carbon dioxide and methane emissions in a per-head livestock tax. This would more accurately reflect the environmental cost of raising livestock, though it would likely increase meat and dairy prices. To make this tax more politically acceptable, the U.S. could adopt a system similar to Austria's Klimabonus, which compensates residents for the costs imposed by a general carbon tax. In summary, a well-calibrated livestock tax in the U.S., incorporating the cost of both carbon dioxide and methane emissions, could drive sustainable agricultural practices, balance environmental and economic interests, and potentially gain public support through consumer compensation mechanisms. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email newsletter form. We'll see you back here tomorrow, and until then, remember, 20 years from now, you'll be more disappointed by the things you didn't do than by the ones you did do. So did do all the things you want to do, the things you're going to do, so that when you regret, you're going to regret the things you didn't do. So do the things. Do more things than you don't.